We have the book here that's working. This works comparably because we've stuck the actual table of contents outside the text. Although, watch how elegant this is. You can just scroll, or you can scroll forever. We do that with this text, but our text is 400 pages. It is not a single document really. It's about 40 or 50 different documents. This matter is before the court on defendants Gopher Media, April 2, 226. Drunwin's motion to dismiss the plaintiff's first amendment complaint pursuant to Federal Rules of Procedure 12b2. This is the hearing. Plaintiff Advice Media LLC was represented by Jonathan Gold. Defendants Gopher Media, Drunwin, were represented by Kennedy Nate. And defendant Connor Morris was represented by Nicholas Wilde. The court took the motions under advisement. After carefully considering the memoranda filed by the parties in the law and facts pertaining to the motion, the court issues the following memorandum of decision and order. Really even expression there, by the way. Not too much prejudice. Plaintiff Advice Media dismisses My Advice. Defendant Gopher Media LLC dismisses Dr. Multimedia. The companies are competitors. DMM Digital Marketing. See, this type of content is kind of interesting because we're looking through things in real time, right? And so, if we're a professional journalist, one of the things we're looking at is we're really looking for deep reads on not really on methodology, but on process. The way journalism is covering legalism um, is essentially by essentially analyzing what's this process, what's the next process, what's the next process. So what the journalist is expected to do in a mainstream terminology, or I guess we call it an upmarket terminology, not a mainstream terminology. What the journalist is expected to do here is pick up the text and to say here the judge has agreed to doing this thing is in a reasonable order. Uh, this notion of careful consideration, we usually implicate the idea that he or she is confident in how this matter is being reasoned. There isn't anything going to be left up in the air at the end of this opinion, and then we move forward here. We get an introduction on these parties and their business. Apparently, they're doing so DMM is a digital marketing agency supplying internet and online marketing services to pharmacies, veterinarians, chiropractors, and doctors nationwide, including website development, content creation, social media management, online review management, email marketing. So in theory, you know, we're looking at a story here where the judge is really going to tell us what does it mean to specialize in medical internet as a marketing circumstance, and online marketing isn't it's not like super narrow, right? Like like these guys might put up billboards and stuff. Utah company, Nevada company. My advice, my advice. Oh, there's a little break there. Yeah, yeah. My advice to you is to not fuck around. Jesus Christ. My advice claims that Morris and Wynn disparaged my advice, stole clients from my advice, and diverted those clients to DMM. At the outset of the place, Morris signed an offer letter agreement to protect information, assign inventions, prevent unfair solicitation. The agreement, an offer letter of my advice, agreed to compensate Morris at an agreed upon rate to provide him with certain benefits, and Morris agreed to keep the terms and conditions of his employment confidential. In the agreement, Morris agreed that information concerning my advice, business, technology, business relationships, or financial affairs that my advice had not released to the general public was proprietary information would remain my advice exclusive property. Morris agreed that either during his employment or after his employment he would not disclose any proprietary information to anyone outside my advice for any purpose other than his employment. So here we essentially have a restatement of the contract, and that tells us that the contract is going to define the depth of care in this process. And then here we get some details on Morris and what the hell he was doing with these two companies. Um, During his employment, Morris had access to my advice client list, and the agreement Morris also agreed to 12 months after the employment did not solicit divert or take advice anyway from my advice customers. Prospective customers who violated its non-solicitation during the restricted period be extended by such violation. Morse also agreed not to disparage my advice or interfere with my advice relationship with customers, respectively. Both the offer letter and agreement came form. So this is a difficult part because this implicates the notion of contract theory here. And this is a more subtle notion in the context, but you say if you violated this non-solicitation provision, so this is an awkward clause, right? In the agreement, Morris also agreed that for 12 months after we've not solicited, I've take away my advice customers. So if you violate this non-solicitation provision during the restricted period, the period would be extended by such a violation. So what is that? That's a non-limited term. So it's penalizing the contract holder for violating the contract, right? Um, So typically, you're sued when you violate a non-disclosure agreement like that or a non-compete clause. Um, so so obviously, Morris, most of us, without even thinking about the judge is looking at this and he's saying, well, this contract provision, extensively isn't really consistent. This guy Morris here is really testing the bounds of the law. And that's really what that signals is that we disfavor Morris already on terms of his defendancy, in terms of the structure of the complaint. It is here we're really hearing the complaint in favor of the plaintiff. And so almost immediately after his employment with My Advice ended, My Advice led Morris began contacting My Advice clients, inappropriately tried to solicit his clients to the business of DMM. My Advice clients informed My Advice that Morris made false and misleading statements that My Advice clients have informed at least 27 calls from DMM employees Morris and Wynn also sent texts and emails to My Advice clients. My Advice alleges that Morris and Wynn would claim to be My Advice employees to get past gatekeepers and then talk to actual My Advice clients and business owners to like their client. DMM Morris Nguyen also considered there was an emergency of some kind that might claim My Advice. With its website marketing My Advice alleges DMM authorized Morris Nguyen to use these false statements to steal My Advice business, blah, 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 blah. So there it is. So that's the allegation, right? So you want to think about this: contract, tortfeasor, and injury. And so we're looking. So most of us at this point are looking for injury and fact narrative. We're looking for the point where the injury comes into focus, right? So my advice is lose at least 8 clients. And my advice, my advice. The judge keeps trying to give you his advice. And Utah clients generated $6,060.30 in revenue per month, which has now been lost. That's a fairly good client list. I mean, it's a little company. Probably wasn't making enough money. So there we have another speculative motive. That doesn't come up in there. That won't come up in here. Guy's being sued. If he even breaches contract, it doesn't matter what his motive is. My advice brought this lawsuit against defendants alleging breach of contract against Mars, intentional interference with economic relationships, Mars, claim against DMM. I mean, unless he can prove it was defamation. Defendants moved to dismiss the case for lack of personal jurisdiction under federal rules, so proceeded 12b2 of the alternative for transfer 28 U.S. section 1404a, or in the alternative transfer jurisdiction. That's an important clause, right? Because here we understand that the primary discussion happening in terms of the case isn't a dispositive issue, but is actually the defendant's motion to dismiss. So the defendant's motion to dismiss is pretty point blank, right? And if we look back here at the docket for the case, right? So this was filed last February of last year, of 2025. Order to propose a schedule that issued this. It actually was filed a little before that. So that's been incubating for about a year, and it looks like they're getting documentation coming through the case, excess pages, extension of time to file response, reply, amend complaint, or motion typical corporate lawyers, right? And you go extension of time to file response, reply, file excess pages, withdraws counsel. Somebody actually withdrew his counsel on that case in February. That's kind of far out. Order on motion withdraws counsel, and that's if we're really following this case, uh, the issue on that is probably determinate here. We'll just read the judicial opinion for now because it's free, and we already have it in front of us. The defendants argue that this court cannot hear this dispute because it doesn't have personal jurisdiction over them. The law of the forum state and constitutional due process limitations govern personal jurisdiction in federal court or public insurance company versus Continental Motors. And it was to say, have personal jurisdiction. The law of the forum state and constitutional due process limitations govern personal jurisdiction in federal court. The law of the forum state and constitutional due process limitations govern personal jurisdiction in federal court. We can always use that, right? If you're ever bringing up one of these judges, and so it's kind of an issue, you know, and this was for us in a more personal respect. This reflects on the idea of judicial consent and the idea that the personal jurisdiction of a party filing a complaint or filing a process is not different, but could differ than is whether or not the judge would be pleased with some part of the ruling. We have these myths of attorneys trying to please judges, um, and supposedly that's quite it's relatively compelling in that respect. Uh, but generally speaking, due process limitations, either implicate statutory constructions or issues forensic orientations and issues. So due process requires both the defendant purposely establish minimum context within the form state and the assertion of personal jurisdiction would compare fair play and substantial justice. My advice does not allege that there's a general jurisdiction over defendants in Utah. Therefore, the court must only determine whether there is specific jurisdiction over each defendant. Specific jurisdiction means that a court may exercise jurisdiction over an out-of-state party only if the cause of action relates to the party's contacts within the forum state. Um, so that's a fairly critical ruling. Specific jurisdiction calls for two-step inquiry. This is a similar. If we really analyze these questions, these are similar questions about things like predominance and supplementary authority of the court. If the court can issue on this subject within the same state, and we can say that one of those parties, is grounded in that state, um, then you can usually find personal jurisdiction over it. But in some respect, it's not supposed to be mixed up at all. So whether the plaintiff has shown that the defendant has minimum contacts with the foreign state, with the forum state, and so whether the defendant has presented a compelling case that the presence of some other considerations render jurisdiction unreasonable. And this problem here, in terms of what we're discussing, is whether the plaintiff has shown that the defendant has minimum contacts from within the foreign state. That's going to implicate a longer question of business context. It is, if I'm doing business in this state, is this what I'm doing? It also implicates the question of, if a person's committing a tort violation, or let's say he or she is violating like a licensure agreement, like a condition of licensure. Those questions are more and more critical between states because it implicates either the idea that different state laws govern different state issues, which implicates the idea of a separate court. So if I go from Nevada to Utah, and some torts I committed in Nevada, while some I committed in Utah, well, guess what? You're filing in multiple jurisdictions there, unless you're the party aggrieved directly. And uh, and so whether the defendant has presented a compelling case that the presence of some other considerations would render jurisdiction unreasonable, and of course, the compelling case that the presence of some other considerations would render jurisdiction unreasonable. That's kind of the melodrama of the defendant's jurist. Um, these guys, we're living in a period where we're being very, very forgiving of essentially kind of very weak and bad political testimony. Um, and there are people who've been cultivated into sympathies with those testimonies. And what we actually read Kimball in that position there with the omitted citation, because it's not really going to come up in this instance. And it looks like he omits another one there, or it could be sitting inside of the ruling position. Is this idea that we don't need more critical jurisdiction, but that's a higher level critical evaluation. And we could look deeper into the case. The minimum context test for specific jurisdiction encompasses two distinct requirements. One, that the defendant must have purposefully directed its activities at residents of the forum state, and two, the plaintiff's injuries must arise out of the defendant's forum-related activities. So if you pay close attention to this, this means that you have a moment here where the individual has purposefully directed its activities at residents of the forum state. So this implies the idea that I'm crossing state lines to commit this tort, and that the purpose is in some respect to direct from this one location into the other. And then and that's also fairly critical review, right? Like if I go into a context where I have to say protect a contract interest, and I essentially send someone out of state to protect that contract interest, but that person happens to violate that contract interest in that same action, then that measure of intent is compromised in the same term. The purposeful direction requirement applies where the defendant deliberately has engaged in significant activities within the state and has therefore availed himself the privilege of conducting business there. Under the Calder effects test, a plaintiff can demonstrate purposeful direction if there was an intentional action that was expressly aimed at the foreign state, with knowledge that the brunt of the injury would be felt in the foreign state. Quoting Dudnikov v. Chalk, Vermilion, Fine Arts. On a motion to dismiss for lack of personal jurisdiction, the allegations in the complaint must be taken as true, This is really slow reading, by the way. At this case, defendants did not submit any affidavits controverting any facts alleged in the complaint. Therefore, the court assumes the facts of the complaint to be true. Defendants have argued that facts my advice alleged in the complaint are conclusory jurisdictional allegations rather than well-pled facts that support personal jurisdiction. But the complaint clearly has facts regarding the individual defendants. Targeting, he's basically going crazy right there for a moment. Targeting known advice clients by claiming to be my advice employees and then trying to get them to switch companies. Morris knew my advice clients. He shared that information while employed at DMM. They targeted those clients to switch from my advice to DMM, and they knew that my advice would lose those clients. My advice also lists the amount of business it lost per month from Utah clients that switched to DMM. Those facts are not conclusory jurisdictional facts. They are facts relating to parties' contacts within the state of Utah. This is not a situation where a plaintiff has merely recited the elements of a claim or made vague allegations that customers were being contacted. My advice listed specific clients, the nature of those contacts, and the damage that it incurred. This, ugh, I don't even want to. So here we are, and then we're gonna. These are the Rule 8 predicates, right? And so here we're essentially looking at Rule 12 and 12b2, and we're trying to say, well, does the Federal Rule of Civil Procedure uh, does the Federal Rule of Civil Procedure really resolve here that we don't have a whole case? There's no jurisdiction for the case. And there are adequate allegations to support jurisdiction on the remaining claims as well. He targeted my advice clients when he agreed not to do so, shared that information with his new employer, who was a competitor, and used misrepresentations to clients to induce them to switch companies. These actions resulted in the loss of 8 clients, 6 of which were Utah-based clients. My advice contends that both NIN and DMM are subject to specific jurisdiction in Utah because they purposely directed activities that Utah caused injuries to my advice. Basically, they're getting sued at that point. Uh, and it says, my advice claims Min is subject to Utah jurisdiction because he allegedly worked with Morris to solicit and establish continuing relationships with my advice Utah-based my advice employee. The allegation that he claimed to be a my advice employee to gain access to my advice clients demonstrates he was targeting my advice. Once obtaining access to the clients through misrepresentations, the aim was to take that client away from my advice. It is a simple inference of the complaint that the only way Nguyen knew any of these clients was from information improperly shared with him from former my advice employees who were under a contractual obligation not to share such information. So there's a little bit here missing already. Once obtaining access to clients through misrepresentation, it is a simple inference. Uh, One of the things that's coming up here, uh, the allegation that he claimed to be a my advice employee. What do we got here? We're at 19 minutes. To gain access to my advice clients demonstrates that he was targeting my advice. Once obtaining access to the clients, one of the things that comes up here between Nguyen and Morris, it it looks like is was from information probably shared with former employee. The city poached several Utah-based clients from my advice. He caused harmful effects to my advice. As in case that he was a my advice employee. The allegation that he claimed to be a my advice employee to gain access to my advice clients demonstrates that he was targeting my advice. Once obtaining access to the clients through misrepresentations, his aim was to take that client away from my advice. It is a simple inference from the complaint. By the way, knew any of these clients was from information improperly shared with him from the former my advice employees who were under a contractual obligation not to share such information. Constitute minimum contact sufficient. And so therein we get to a minimum. And what's interesting here is we get to a minimum sufficiency of cause. And the question on minimum sufficiency of cause relies on further discovery. It's not super difficult beyond that. Interestingly, though, it seems like there are other people who are in on this at that point, and that narrative hasn't been more evenly exposed. My advice argues that DMM forced minimum contacts with Utah through its agents Morris and Nguyen. DMM is subject to Utah's jurisdiction because it transacted business in Utah through its agents. Utah's long-arm statute extends to any person or personal representative of the person, whether or not a citizen or resident of the state who in person or through an agent acts to transact business in Utah, contracts to supply services or goods in the state, or causes any injury within this state. The Supreme Court has also recognized that any agency relationship may give rise to contacts sufficient to subject a defendant to personal jurisdiction. Racer Technologies v. Morgan Stanley, Walter v. Fiore. That's the Utah Supreme Court. And these guys are always actually balanced. What's his name? He's Matthew Durant, and and there's another one who's also very good. Is retired. There's several judges on that court who are quite competent, um, and they tend to simplify their rulings rather than expand them or blow them up. There is a there is a period in the state of Utah coming where we're very likely to see a radicalized Supreme Court, very similar to some place like like Tennessee or Oklahoma. Um, and that's kind of what's going on in this case here. And when we're talking judicial malpractice, that's also what's going on there. Is you have attorneys who don't ever want to fight with the judge. I just want to be able to agree with whatever they're going to do, and that's how we'll practice. We'll take the cases that win. We're not going to win or lose more cases. Those are, the victims of judicial malpractice win or lose those cases. DMM is also subject to Utah's jurisdiction because Utah recognized the conspiracy theory of jurisdiction. And DMM allegedly participated in conspiring, targeting Utah. Utah Supreme Court explained the acts of a third party, such as an agent, can, in some circumstances, provide a basis to exercise jurisdiction over an out-of-state defendant. The court explained that a conspiracy is an agency relationship, so an act taken during the course of conspiracy may lead to specific jurisdiction over a defendant. As long as the defendant can reasonably anticipate being hailed in Utah courts, personal jurisdiction of the conspiracy theory satisfies due process. Here, my advice alleges that DMM participated in a conspiracy to solicit and steal the clients of a Utah company through false and misleading statements. Due to its participation in this conspiracy, DMM could reasonably anticipate being hailed into Utah court. Therefore, it is subject to jurisdiction in Utah. The defendant's motion seems to be based almost solely on the fact that of the 27 specifically identified calls, none of them was to a Utah-based My Advice client, but the complaint alleges a pattern of misrepresentation to gain contact with clients in order to convince the client to switch to companies, and 6 Utah-based clients were lost as a result of this targeting. The complaint identifies the 6 Utah companies by name. The complaint therefore can only allege that the same type of contacts were made in Utah to cause those 6 Utah-based clients to switch. The complaint alleges that there are repeated contacts to Utah-based clients. Defendants knew those clients were My Advice clients and knew that loss of business would harm My Advice in Utah. The defendants did not submit any affidavits to controvert My Advice's allegations with respect to those 6 clients or any of the others. The court concludes that those allegations are sufficient to demonstrate that contacts were made to Utah clients with the intent to harm My Advice, a Utah company, and with the knowledge that My Advice would suffer harm in the state of Utah. In addition to having minimum contacts with the forum, exercising jurisdiction over defendants must be fair and reasonable. Courts inquire whether the exercise of personal jurisdiction would offend traditional notions of fair play and substantial justice. After minimum contacts are established, it is incumbent on defendants to present a compelling case that the presence of some other consideration would render jurisdiction reasonable. Courts determine whether jurisdiction is reasonable by considering the following factors: 1. The burden on the defendant; 2. The forum state's interest in resolving the dispute; 3. The plaintiff's interest in receiving convenient, effective, and effective relief; the interstate judicial system's interest in obtaining the most efficient resolution of controversies; and 5. The shared interest of the several states in furthering fundamental social policies. So this is a fairly critical circumstance here because what we're looking at here are questions of interstate burden, jurisdictional burden on people signing contracts and engaging in business and essentially committing tort. Uh, and and this section here, as a rule, should relate to some of the stronger construction above here, where we're talking about essentially where we're talking about the entire notion of the contract construction here, and let's see, in the offer letter and agreement. Um, and that's pretty much where the judicial opinion takes its force from. And so the way the judges looked at this opinion is he's essentially picked it up and he said, well, there are really 3 points that can actually proceed here. And they're kind of racing across the thing at a snail's pace, right? You have the plaintiff. The plaintiff can always drop the case. You have the contract. The contract can always will almost certainly vindicate the case if it isn't dropped. And at the outset of employment, Morris will either be shown to be a tortfeasor or not a tortfeasor. And the same for Nguyen. Although this complaint here does there's Drew Nguyen. Let's see, where does Drew Nguyen come up in here the first time? Yep, Morris Nguyen would insinuate the agency was an emergency of some kind of claim. Issues with website marketing. Oh, they're terrible. This is an emergency. If they believe it's an emergency, they'll switch. How are they gonna ever find out? Like, well, I just watched all my fucking clients walk away. Anyway, you think I don't know my business? Anyway, the court therefore concludes the amended complaint alleges minimum context to exercise jurisdiction for defendants in this area. So here we are, and then we get a little discussion of venue. Our defendants have argued that because this court cannot exercise personal jurisdiction as to all defendants, that argument's already mooted. Um, Therefore, dismissal. Defendants argue that the amended complaint fails to plead a breach of contract. That's also resolved. Breach of contract. So here comes breach of contract. Breach of contract is funny. This one's always relevant to us right now. breach failed to demonstrate that any of Morris' alleged conduct breached the agreement or that my advice suffered resulting damage from the alleged conduct. In Morris' agreement with my advice, he agreed not to disclose any proprietary information, my advice, including customer identities, or to use any such information for purpose other than. Also agreed. Defendants argue that the admitted complaint alleges numerous facts supporting a claim that Morris breached the agreement's and duties and, by doing so, caused my advice to suffer damages. The admitted complaint alleged that Morris was the account manager for 3 clients who terminated their relationship with my advice and signed contract with DMM. Moreover, the breach of contract claim does not sound in fraud. The allegations do not need to be made with particularity. Even if it did, my advice has alleged specific instances of breach. Therefore, the court finds no grounds for dismissing the breach of contract claim against Morris. Anyway, defendants argue that economic loss rule bars my advice claim. And of course, when a conflict arises between parties to a contract regarding the subject matter of the contract relationship controls. See, look at that. That's the weakest reasoning in the world, right there. And that's why and that's why the memorandum decision order granting part denying part defendant's motion to dismiss the economic loss rule otherwise is could actually be true. But let's see here. To determine whether the economic loss rule bars court rule and standing, focus on the nature of the duties existing parties, specifically whether the duties and parties courts result parties contract arising from non-contractual sources. The tort alleges a breach of duty. If this claim is barred, the plaintiff can sue only for contract-based remedies. KTM Healthcare. And that's a huge argument, right? It's sort of just breach of duty that the contract itself imposes, then the claim is barred. The plaintiff can sue only for contract-based duties. For contract-based remedies, and that actually comes to that begins to fly in our face here a little bit. Um, but of course, we have to talk. That doesn't necessarily implicate an ultra virus breach of contract, right? Like if we're engaged in a contract and somebody violates part of the contract, and I sue to fix it because somebody's like, oh, I didn't do that, and the judge says, no, you did it. It's like, oh, okay. I mean, that's essentially what that amounts to. It is, in some respect, its prejudicial posture is not the same as a question of ultra-virus violations. Um, my advice claim for tortious interference against all mortgage agents, breach of duty. The agreement opposes my advice claim for civil conspiracies based on the duty not to listen. My advice claims for false. My advice, however, contends that the tort claims are based on tort law duties separate and distinct from the duties imposed by the agreement with Morris. The Supreme Court's decision in Grinberg v. Questar Pipeline is instructive on when a tort claim is based on a duty independent of those duties found in the contract. The fact that the exact same conduct is described in both the contract and tort claims, the exact same fine facts, circumstances, or plays indicative of the overlapping duties in this case. The same is true here. In the tortious interference with economic relations claim, my advice alleges that Morris had a duty not to solicit my advice clients and not to make false misleading statements regarding my advice as related to my advice. My civil conspiracy claim similarly alleges that Morris had a duty not to solicit my advice clients, stealing those clients for DMM through false misleading statements. The other argument that lurks in this is the argument on good faith practices. It is never a good faith practice to essentially mislead or otherwise coerce somebody, even if it were not necessarily fully misleading. It's never good faith in contract practices to pressure a former client to leave on a caprice, especially or on a retribution. Um, some people will say get real, but getting real and just telling it like it is are sometimes two different things. And whether you have a right to do that seems to be at the center of the tort. My advice's opposition concedes the overlapping nature of the claims by recognizing all 3 claims require at least showing that the defendant solicited the plaintiff's clients to disparage the plaintiff. Therefore, exactly the same conduct is described in both the contract and tort claims. The exact same facts or circumstances are plain. In such a situation, the economic loss doctrine bars the tort claim against Morris. Accordingly, the court grants defendant's motion to dismiss the tortious interference and civil conspiracy claims against Morris. And that's a pretty fierce argument, right? Um, to determine whether the economic loss rule bars a cause of action sounding in tort. And so just reread that to kind of capture that, right? When a conflict arises between parties to a contract regarding the subject matter of that contract, the contractual relationship controls, and parties are not permitted to assert actions in tort in an attempt to circumvent the bargain they agreed upon. Ryhard v. Yates, and that's a 2018 Utah case. When a party's tort claim is a mere duplication of its breach of contract claim, the economic loss rule applies, and the tort claim is barred. And so the idea here is that in theory, because what you're claiming is economic loss and not tort injury, you defer to the economic loss rule, and that's actually a fairly hard claim. You have to prove against parties when you're talking about, we compare a different circumstance where you're actually comparing an ultra virus tort. Uh, I mean, the difficulty here, I think, is that the nature of the breach of contract rule and for us, the breach of duty should be clarified. Uh, from my perspective, I'm trying to think about why we lost in a district court claim. And one of the things we argue is, of course, that there's a duty in that contract uh, to maintain the credibility and the good faith practices of all of these people in business. Um, and one of the things that comes up in these things is that, well, these are we're alleging that these things are defamations, that they were never precedented, um, and that there is no basis within the corporate record to prove or to provide that those things were provided, and that there was opportunity to review whether or not that should be providable, and that somebody refused to take that step in such a critical circumstance. And it's an ultra virus claim. And oddly enough, I think that uh, a company suing a former employee, or another company adopting that information, um, has an interesting disposition, because tortious interference, uh, turns out to be a pretty big idea. Let's look at this for a sec. I mean, because we're looking at Gopher Media LLC, Doctor, and Doctor Multimedia. So you're seeing these two guys, and the tortious interference claim should really apply against Gopher Media as a leading claim, because there's no breach of duty between the two, and the idea that these other characters are hired or working independently while under such a contract claim is pretty bad. Anyway, economic loss rule, and then the economic loss. Um, And again, to be totally honest, the economic loss rule isn't clear, because as we read it here, when a conflict arises between parties to a contract regarding subject matter, that contractual relationship controls parties not permitted to assert actions in the tort to circumvent the bargain they agreed upon. Tort claim is barred is a mere duplication of its breach of contract claim. The economic loss rule applied, the tort claim is barred. Um, so the idea here is that the economic loss rule for in terms of breach of contract. And I don't know, from one perspective, that seems beside injustice. But I think the idea is that you can only sue for economic losses um, in those types of conditions, because essentially the guy isn't breaking the law. Uh, Defendants argue that my advice tortious interference claim against Morrison win. Technically, it's a violation of civil integrity in some respect. It's hard to. It would almost be like a separate standard of statutes at some point. Like, it would almost be like a separate standard for tort. Um, Anyway, so through improper means, including false, misleading statements, with the meta complaint does not sufficiently identify any potentially improper means with particularity. Uh, and it requires the plaintiff seeking to rely on allegations sounding in fraud must set for who, what, when, where, and how the alleged fraud. U.S. ex relatio Hunt, Section 9, a prima facie case of intentional interference with economic relations requires allegations: 1, that the defendant intentionally interfered with the plaintiff's existing or potential economic relations by improper means causing injury to the plaintiff. The amended complaint alleges facts which, if accepted as true, establish all three elements. It alleges that Morris and Wynn specifically targeted my advice clients, contact numbers of my advice clients, made false statements to those clients, including falsely stating that they worked with my advice in order to even get them to talk with them in the first instance. The amended complaint then alleges that Morris and Wynn told my advice clients false statements regarding alleged problems my advice was having in an effort to get them to switch to DMM. It also alleges that these actions caused damage from others to and the relation to my advice and contract DMM. Defendants do not dispute that they interfered with my advice's economic relationships, but they argue that my advice does not describe their interference with enough detail. Defendants are right that tortious interference claims based on false and misleading representations must be pled with particularity. But my advice lacks personal knowledge of Morris and Wynn's false statements because it was not on the calls where they made these statements. My advice learned that these statements came from its clients and included what it was told in the amended complaint. Courts have made it clear that less specificity is required, whereas here a plaintiff cannot be expected to have personal knowledge of the facts constituting the wrongdoing. Arena Land. An inventory company, Petty 906, we can actually use all of these precedents on a reply section. The amended complaint includes more than enough detail regarding the alleged false and misleading statements underlying my advice's tortious interference claim, particularly when red lighted my advice's lack of personal jurisdiction, personal knowledge. So, for the sake of argument, we go back here. So here's the amended complaint. The amended complaint comes in July. So here's what happens in that case process. So you get a scheduling order and extension of time to file answer, an order of motion, answer, admission, so it comes into court, another one, and then it looks like we file another main document, and this document in March is uh, very likely a motion to dismiss, and that's right here, dismiss for failure to state a claim and dismiss lack of jurisdiction. That comes up here on March 28th. And then extension of time to file response, extension of time to file response, extension of file response, so that's 2-3 weeks. Order on motion for extension of time for response, and then we get file excess pages, order on motion for lead to file excess pages. And so they're kind of just buying time against it. Main document, extension time to file response apply, order on motion for extension time to file response apply. And then here comes the amended complaint. And then the order on motion to amend the complaint, order on motion to amend order on motion to dismiss for failure to claim, dismiss, and then so that essentially survives the whole thing all the way up into August. So the cycle in this process for dismiss has seen a couple of these issues. The big question is, of course, well, what level of sensitivity is the attorney taking in this precedence? And this is the pro se question, um, because and it's an important pro se question only because the amount of time the attorney takes writing this, they're busy, they're doing other work. The big question is what's actually happening in the case. Why do we believe in the circumstance that uh, that the that the complaint should be dismissed at that phase, right? I mean, there's not like a discovery phase required here. These guys have all of the information. They just haven't really organized all of it. They're not asking for other information from other people. In theory, they're doing this. In theory, at worst, they're doing discovery in the background after the initial filing, and they're just waiting for material to come back. So let's file this right away. We'll drag it out, and that's acceptable. And it shouldn't be considered too hard on the other people. In our circumstance, we'll look at that kind of thing and we'll say, well, the jurist here bearing prejudice implicates the idea that we don't know how to handle that kind of case circumstance when we should courteously amend the complaint. And the problem I think for these guys is that while they're drawing out for us a question on that bar, we're also clarifying that we're also clarifying the same disposition prematurely. So what they're doing is they're essentially collating the wrong case in a pretrial phase on the basis of what you'd call informality of the complaint. And of course, the complaint is informal because, just as we were reading here in Arena Land v. Inventory Company v. Petty, we don't have all the information to know the full list of incidents and defamatory action that we're taking against the victim. Lanham Act and UCLA claims. Defendants claim that my advice is not alleged as Lanham Act and UCLA claims with sufficient particularity ignores what is actually alleged in the amended complaint. The Lanham Act establishes liability for certain false or misleading state representations of fact, including false misleading representations likely to cause confusion or to cause mistake, or to deceive as to the affiliation, connection, or association of such a person with another person. 15 U.S.C. Section 1125. My advice alleges that Morris Wynn misrepresented. We're not covering our names, by the way, guys. We don't care that much. This stuff is all on the public record. The UCL makes it unlawful to make certain untrue or misleading statements and to disseminate such statements as part of a scheme to sell personal property or professional services. Respondat superior. Respondat superior itself is not a cause of action or cognizable legal claim, Gardner v. U.S., and that comes out of the District of Utah. Pretty, yeah, that's a pretty good report right there. Because it is not an independent claim, the court dismisses it as a standalone claim. But my advice has sufficiently pled as a Respondat superior theory of vicarious liability against DMM. The amended complaint alleges that Morris and Wynn were acting within the scope of their employment with DMM. The tasks Morris and Wynn were employed to perform included tasks described in the amended complaint. DMM had the ability to control Morris and Wynn's conduct, including conduct described in the amended complaint. Morris and Wynn's conduct occurred during the hours and the locations of their employment, and their conduct was motivated in whole or in part by the purpose of serving their employer's interest. While respondent superior is not itself a claim upon which where relief can be granted, the amended complaint alleges that facts supporting holding DM vicarious liable for actions affected the tort claims, and that's natural as well. Respondent superior is a fairly natural case argument. Uh, Judge Kimball here is a little bit too capricious. He's defensive for some reason. Um, uh, you don't dismiss it. You can, in theory, you could dismiss a case misstated under doctrine respondent superior. Um, but again, it's a natural argument that issues from proper positions. It's basically it would be like a weak or vexatious attorney trying to argue it, I guess, in intentional error. You wouldn't want to feel bad about it. You wouldn't. Anyway, defendants also argue civil conspiracy is not a cause of action. Under California law, civil conspiracy is not a cause of action, but a legal doctrine that imposes liability on persons who, although not actually committing a tort themselves, share of the immediate tort fees of a common plan or design in its perpetration. Applied Equipment Corp. You live in Saudi Arabia. Likewise, under your law, plaintiffs seek to plead, prove civil conspiracy must first state, then prove 5 elements. Combination of 2 or more persons, object to be accomplished, to be to the minds the object course of action, one or more unlawful overt acts, damages as approximate result thereof as for all peg and estate v canon. Thus, Utah law also appears to recognize that although though civil conspiracy may be in certain instances a cognizable claim, it is necessarily a derivative one. Defendants assert that my advice has failed to allege a single unlawful or overt action by any defendant that would support a civil conspiracy claim. In other circumstances, I mean, the closest you would come in that kind of circumstance is like defamatory or malicious communication, um, and essentially, the other side of it would be like a stalking allegation. Um, a company arguing a stalking allegation at that point is pretty serious when you find 27 people who are not like on your team who are like not there and or who are being courted out of your place. You could argue that that was harassment at a certain level, but it doesn't fit the canonical rule for intentional harassment because it isn't specifically targeted. It has these kind of latent fraud elements um, that are actually designed to cultivate wrongful advantage without necessarily attacking the individual per se. I suppose if they'd done this to an individual, you could argue harassment or um, personal damages. Um, in these instances, it falls back into the economic loss claim. Uh, a corporation cannot conspire with itself or its own agents. The agents of such entity cannot conspire with the entity itself. Blah blah blah. It's a little bit weird. That's a bad pleading there. That's a bad pleader right there. My advice is allegations for a civil conspiracy all relate to Morris DeWitt's actions taken on behalf of DMM, their employer, and of course their employment, DMM. Therefore, my advice civil conspiracy claim for fails, even if any unlawful overt act was pled. Accordingly, the court grants defendant motion to dismiss civil conspiracy claim. Conclusion. Blah, blah, blah. And there's a delay Kimball signature. Anyway, so and we'll save this. We'll save this thing. The reason we're reading this is because this is the judge who's committed a conspiracy against us. And uh, um, why aren't we signed into court this year? Stack. Um, the interesting problem that we find here, and let's see, we've got a position here on Kimball here in the confession. Let's see here. Dun, 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 dun. Running through methodology here. It was this case here. In 2020, less than 2 months after the Supreme Court had denied, there's an issue there, petition for a rehearing in the previous case, I filed an amended version of the complaint, which held a comprehensively more perfect written standard. You know what we should do? We should get the next page section up here in the crossbar. I did not intend to provoke the court's prejudice, but address the need for Kelly fraud in a supplemental briefing showing case precedents that clarified the same Rooker-Feldman question. It was the same case, but the judge presiding, Honorable Deb Benson, deceased, took cue from Honorable Chief Magistrate Paul Warner. He recommended another false term for cloture. The summary opinion declared foreclosure of the civil plaintiff's rights is implied against the protectual layer of the previous brief. I instantly recognized fraud in the court because I had discussed it in part in the self-amendment brief where I sought to have preempted his stop bell and showed the limitation of the statement of jurisdiction. Honorable Judge Benson, who committed fraud in the court, refused to recuse upon the motion demonstrating the violation of civil integrity of the court and forced the case into appeal phase. Judge Benson subsequently died of a deadly brain tumor while the matter was pending transfer, and the case was then assigned to Judge Dale Kimball, whom we were just reading, who promptly issued false declaration of appeal in bad faith without demonstration of any other basis than form of judicial affidavit. He betrayed the open court and the Constitution of the United States of America in the same pattern as Judges Newkirk, Warner, Kelly, and Benson. Judge Kimball expected us to abandon the appeal either in honor of the malpracticant Benson or in honor of his own political image, declaring the appeal in bad faith. He rather projected the circumstance of collateral order wherein the circuit district court judge may be construed in bad faith for a prioritized appeal policy within the U.S. government. The same position we find now. The malpracticant may find criminal and partisan audience in the U.S. appellate courts. On appeal, the circuit panelist, Honorable Ms. Nancy Morris, authored a derisive and maniacal and solipsistic derision of the case for the plainly broken Benson opinion, more or less appearing to show total confusion about the rational difference between claim and issue preclusion, neither of which were satisfied at the summary judgment principle. The panel declared the court was incapable of retroactive review of a fraud in the court de facto, as if by casualty of a big lie. The fact is, they mocked the they mocked the there's a couple typos in this section. They mocked the Sierra Facia standard of the fraud in the court rule. Oh no, that's right. And failed to show why the immediate case could not be taken independently. She rendered a false delineation on issue and claim preclusion likely intended to detoxify the soul of the victim, where all the United States bears imminent precedence to all its people under the Constitution of the United States of America. It is like an ecclesiastical corruption of blood, and would promise harm the family and offspring. Judge Morris rendered the mens rea condition for both quorums in terms of undefined lower court prejudice. And Judicial under the transfer committed political fraud against us, and if we did not deserve the dignity of the United States, such expressionism is consistent with intent over cultural cleansing and genocide, both political terms now within the active practice of the United States administration. They have harmed us under internationalization of what appears to be a criminal imperial conference within the strict Republican Party. The same is advanced by the Associate Justice Gorsuch, whose origin story traces through years of apparent appellate malpractice and results in a limited agenda in the Supreme Court of the United States of America, which he does not advertise but declares by implication, and the same advanced by the awkward and incompatible tenure of the presidency by sedition, the lack of beneficent intent on organic provisionalism, so their opinions appear malefic and revoke the Constitution from a party. The practice in the Supreme Court contradicts the prima facie authority of Rule 60D, and the court refused to check the fraud. To regard malice in the circuit court, all the malpracticant needs to do is ignore the pleader. They have gasted the entire case in the spirit of party preference and dramatically increased our real interest to compel a constitutional non-politicized resolution. Anything short is maintained sedition. So there's a few typos in that. We'll fix those at a different juncture here. Um, but I think that has to do almost primarily with uh, whether or not we understand what it means for a judge to commit malpractice. Um, See, and these are notes on page 368, 369. Um, and and these are fairly difficult problems, right? The fact is they mocked the Schittophakius standard of the fraud of the court rule. And all Schittophakius means is that it's written on its face what it's supposed to mean. You're supposed to know, and that idea can be kind of controverted in certain cases, right? Like if we're walking into a circumstance and say, well, it's breach of contract, um, and it's and it's a civil conspiracy. and we're showing economic losses. Well, guess what? You're barred up until economic losses because you're just losing money. The personal injury you're sustaining here isn't clear. Your clients know what happened. It can be repaired. Um, if these guys were still working for you, you would just be telling them to change what they were doing. And and that's a fairly big deal. But when we look at cases like that, what we're really looking for is we're looking for dispositions. We're looking for dispositions where people begin to tell us that they no longer. We're looking for dispositions where people begin to tell us that they no longer care for the constitutional law. When we're looking at the Benson opinion or the Benson opinion, this Kimball opinion, um, there's Louisiana v. Calais there, um, which is a different report here. Um, uh, but when we're looking at an opinion like, oh, where did I find these guys at? There it was. Like Advice Media versus Gopher Media, and those two characters. Um, there's Daphne Auberge. Um, uh, one of the things we're looking for is a more conferential construction of the court or conferential construction of the case. And again, in these instances, we don't really get a plainly conferential construction up until we're looking at those omitted citations. Um, those are the places where you would begin to, you know, where the judge him or herself would have to contemplate a malpractice. And it's a really interesting tell. Um, and it indicates, for those attorneys who are practicing that he has committed malpractice on a case such as this. And my guess is it was ours because we're still trying to get him. We should highlight those sections. Where were those admissions at? Yeah, these two paragraphs here implicate a conferential construction of the court. Um, However, it's not applied. The motion to dismiss comes out equitably. Um, at least on its face, it appears to. Uh, the parties at law are technically more obligated than we are in this phase. Um, yeah, and so that's a fairly clear argument there.